Hi, my name is Jeremy Gordon, and I'm an attorney at Guest & Gray. I'm here to talk to you about compassionate release and whether or not you should hire a lawyer or represent yourself. Now, we get this question a lot. Sometimes someone calls us before they're going to file their motion, and sometimes someone calls us and asks us this question after they've already filed their motion, and sometimes even after the government has responded. Now, if a person is deciding to represent themselves, that means that they're filing pro se, meaning that they're filing their own motion and they're filing it without a lawyer. Now, on the one hand, a pro for doing that is that you write exactly what you want to write in your motion, and you tell the judge exactly what you want for the judge to know in your own words. And many times, inmates explain this to me. I wanted a chance to say it to the judge in the way that I wanted to say it in my own words. Now, on the flip side of that, a con there is that when you write your own motion, then you're held to the same standards that a lawyer is. And while it's true that you are given a wide range of latitude when it comes to writing your own motion, it's also true that you still have to meet the legal requirements. Many times when I read a compassionate release motion that an inmate has written, I find that it doesn't meet all the legal requirements. Maybe some exhibits are missing. Maybe it doesn't have proof that the person reached out to the warden. Maybe it doesn't have all the letters of support that is needed. There are several different things that might not be in a pro se motion. So another con is that the motion is going to be responded to by the government, in this case, the United States. Now, when the United States gets a response together, they're not going to use a person that has no legal experience on their motion. They're going to use a lawyer that's had 5, 10, 15, 20 years of experience writing these motions, representing the government, and trying to keep people in prison. So in my opinion, you should have it as well. You should have a lawyer that has experience, have a lawyer that's done these motions before, has a lawyer that knows what to say, and a lawyer that knows what the legal requirements are. All right, so many times when I am called by a loved one, the loved one reaches out to me and the loved one says, Jeremy, my loved one who's in federal prison wrote a letter to his judge. And the letter says something along the lines of, it's messed up that I'm in here, or I don't like being in here, or the law has changed, or judge, please do something about this. And what the inmates don't necessarily know is that when you write a letter to the judge, then under certain rules, the judge could consider that to be a motion that would be filed. And when the judge considers it to be a motion to be filed, then the judge will order the prosecutors to respond. And many times that letter might not have all of the parts that are necessary in order for the judge to grant relief. The judge says that even if this had everything that was needed for relief, that I still find that under the 3553A sentencing factors, that this doesn't have everything that it needs. And I'm not going to exercise my discretion in order to reduce the sentence. Now, this happens to us all the time. We read these motions and we realize that they don't have that, and the judge wrote something down saying, I'm not going to do this. I'm not going to grant relief in this situation. And that person is without recourse. So it's really important for you to have a lawyer, and it's really important to talk to a lawyer before filing a motion. If you've got any questions, please call our office at 972-564-4644 or email me at jeremy@guestandgray.com. My name is Jeremy Gordon. Thank you for watching.